But I would like to welcome everybody to the SRCAR Legal Town Hall. These things are always very sought after and well attended. We've got a great panel of attorneys here this morning. Of course, we've got John Giardinelli, we've got Ed Zorn from CRMLS, and then joining us from CAR, we've got Robert Bloom. Lots to talk about, and actually on the heels of our previous brown bag update that we got from John, a lot of questions centered around some of the property management, let's just call them challenges and changes that are occurring here in California. So we wanted to make sure that we brought somebody in to address that as well. Some housekeeping kind of flow of events here for you guys this morning, just so there's we can avoid maybe some of these questions. So first off, this is being recorded, so we can make it available for those in attendance later. Also, we do have a presentation from Robert Bloom. He has agreed to share those slides, so we will make sure that we get those shared with the participants here as well. We're going to hear a short presentation from each of the panelists, and then we'll open it up for some Q&A at the end. That way we stay on topic. My only ask of you guys this morning, please bring questions. This is an opportunity to get all of these questions answered. My only ask is that we try to keep these a little bit higher level or specific. Sometimes we can get really into the weeds with a particular transaction. We're going to have about 150, possibly more people on. So I want to try to respect everyone's time and make sure that we're keeping the questions a little bit more broad, so we can cover as much topics as possible. So that's kind of how we're going to roll. We should hopefully wrap up here around 11 o'clock or so, depending on the questions, and we will do our best to get to as many, if not all, of the questions as possible. Before I introduce our first speaker, though, we have a small disclaimer that I'm going to allow our association attorney, John Giardinelli, to let everybody know. So, John.
Thank you, Adam. Again, just to remind everybody, two big things. Number one, this is a general conversation. It is not to be considered specific legal advice on any particular issue that you may have now or in the future. It's just general basic knowledge. Number two, we're going to stay away from questions regarding commission issues and rates of commissions and all of those kinds of issues because of concerns with antitrust. As you know, all commissions are negotiable. I also want to, if it's okay, Adam, thank both Robert, who has been incredibly generous with his time over the years, one of the finest lawyers that I know, and of course, Ed Zorn, who is one of the finest lawyers that I know as well, and just thank them both for their generosity when it comes to their time and their willingness to work with us and getting these panels put together. So I'll turn it over, and then you'll hear from me later on some really fun stuff.
All right, thanks, John. Well, as I mentioned, we do have Robert Bloom here this morning. A lot of questions around the property management arena. So Robert, thank you so much for joining us. Just going to read a quick bio in case we have members here that are not familiar with Robert. Robert joined the California Association of Realtors in 2004 and is now senior counsel at CAR. He divides his time between writing and editing the legal Q&As, which we all appreciate, delivering presentations, and counseling agents on the member legal hotline. He received a bachelor's degree in economics from the University of California, Berkeley, and a law degree from the law school at the University of Chicago. So shout out for our Chicago peeps as well. Robert, thank you so much for joining us this morning. You should have the ability to share your screen if necessary, but I will go ahead and turn this over to you.
All right, well, thank you very, very much. I'm wearing this headset because they're doing some construction outside this unit, and I'm hoping this actually cuts down on the noise, but I don't know if it actually will. So let me share the screen here. Let me share my screen, and I think that does it, right?
Yep, you're good.
Okay, great. Okay, so I'm Robert Bloom, Senior Counsel with CAR. And for this brief presentation, I've written out this list of topics. And the first up is the Tenant Protection Act, otherwise known otherwise known as the TPA. It's the statewide rent control law and just cause eviction law that California adopted. Now, the reason I'm highlighting this law as the main topic is because on the legal hotline, this is really still one of the most common types of questions we get. A lot of people are simply not aware of this law, and it's a critically important law. Now, of course, a lot of people are completely aware of this law, but there's still fundamental questions that we get as to how it works. I'm going to talk about that, and specifically, I'm going to look at the exemptions, which properties are exempted from it, and how to identify if, especially if a single-family property or condo is exempt. Now, if you're selling a tenant-occupied property, then you absolutely need to understand our TOPA form. TOPA standing for Tenant-Occupied Property Addendum. And this form needs to be attached to every residential purchase agreement when there is a tenant in the property. And I also want to touch on the federal rule requiring a 30-day notice when demanding rent. It seems unbelievable, but that is the federal law. Not many people are aware of it. And I also want to look at the local rent control laws in both LA City and LA County. They've made big changes to their rules in just the last 3 months. So I want to talk about that. Okay, but the first up is the Tenant Protection Act overview. California is the first state in the nation to pass a statewide rent control and just cause eviction law. And that came into effect in January of 2020. So it's not a COVID related law. It predates COVID. And basically, for the most part, all of the statewide COVID laws that gave tenants a defense for non-payment of rent, most of those, all of the statewide laws have expired. There's some local laws still in effect. So before this statewide rent control law came into effect, tenancy in California was at will, meaning a landlord could terminate a tenancy for any reason or no reason. You didn't need a reason. And the main limitation was that you couldn't terminate for an illegal reason. Like, you can't evict in retaliation for a tenant making a habitability complaint, or obviously for discriminatory reasons. But generally speaking, other than that, tenancy was at will. Now, what the Tenant Protection Act, or TPA, says is that for most residential properties, you need a just cause reason. And there are only 15 of these just cause reasons. If you can't terminate the tenancy for one of those reasons, you cannot terminate. Okay? But if your property is exempt, then you're under the old rules. Tenancy is at will. So it's all about the exemptions. Okay, and what properties are exempt. And so there's really 3 big categories. Okay, and the first one, well, I'm just going to look. So I'm focusing on these. The first 3 is the 3 big categories. So the first one's easy. The tenant does not get the protections from just cause termination rules until they've been in the property for more than a year. Okay, so it's pretty straightforward. And the second exemption is for new construction. That's new construction within the last 15 years based on when the certificate of occupancy was issued. If it was issued within the last 15 years, then the landlord is not subject to the just cause rules or even the rent cap rules. And this is also a fairly straightforward exemption. If you have that certificate of occupancy within the last 15 years, you're automatically exempt. Now, the third one of the big three, the third one is kind of complicated, maybe very complicated, which is why I put it third. So this one is for single family properties, condos, and mobile homes, as long as they're not owned by a corporation or a REIT. Okay, so LLC ownership is okay as long as no member of the LLC is a corporation. And there's also this very technical thing that if you're not living in your single family property and you're renting out 2 units, then you're also likely not getting the exemption. Okay, but here's the key to, so we call this the single family property exemption. But here's the key. to the single family property exemption. You do not get the exemption automatically. Okay, you can exempt a single family property, but you have to go through the process of exempting it. Okay, and you do that by integrating the exemption form into the rental agreement. Now, if the landlord hasn't done that, then it doesn't matter that it's a single family property or a condo, because the property is subject to the TPA. So you have to go through the exemption process. It's not an automatic exemption. Okay. Now there's other exemptions here. They mostly revolve around the owner occupying the property. But one of the things that I would like people to know is how you identify whether a single family property has been exempted. And I'm wondering, do I have a slide for that? Yes, I do. Okay. So how do you identify, how do you tell if your single family property has been exempted? And the answer is pretty straightforward. You check to see if the exemption form has been integrated into the rental agreement. So using the SRCAR forms, you're looking for that form, the rent cap and just cause addendum, or the abbreviated form RCJC form. Okay, now, if you see it in there, you want to make sure that the box on the first page has been checked, indicating that the property is an exempt single family property. Now, if it's attached to the rental agreement or it's part of the rental agreement and the box is checked, great, then the property is exempt. But if not, it's still possible, but not likely. It's still possible that the property is exempt based upon these other possibilities, and I have them listed as a bullet points. There's some type of owner occupancy. There was a window of opportunity in the first 6 months of 2020 when the law first came into effect. You could have just given the notice directly without integrating. And also, SRCAR isn't the only company that has an exemption form. I mean, there's tons and tons of ways of stating the exemption, so it doesn't have to be in an RCJC form. But most likely, if you don't see the SRCAR form or some other type of exemption form in the rental agreement, it's probably not exempt. Okay. Now, this slide is really intended for property managers. So I put this presentation together not really knowing who the audience was. Some of these are for agents doing transactions, some are. So this is a property management slide. And so here I'm talking about how to actually exempt single family property or condo. So I'm going to refer, when I'm referring to the owner, I'm referring to the property manager, the owner, or the landlord. So how do you exempt it? And the answer is obviously use the exemption form as I've already described. And there's two ways to do it. So the first bullet point is you add the RCJC as an addendum by having both the landlord and the tenant sign it. The landlord signs it, and then the tenant signs it. And then it's an addendum. It's been integrated into the rental agreement. You are done, easy. And the second way is a little bit, more complicated. What you're doing there, well, the tenant is obviously not signing it. So if the tenant does not sign, then you have to incorporate the RCJC by a change in terms of tenancy. So we are assuming it's a month-to-month rental agreement. A month-to-month rental agreement can be changed unilaterally by a landlord on 30-day notice. That's what you're doing. So you take your change in terms of tenancy form, you attach the RCJC to it, you serve both at the same time, because it's really one document, in the same manner as a 3-day notice to pay rent or quit, and then you wait 30 days and voila, the rental agreement now has an integrated RCJC and it's exempt, making sure that the box on the first page of that RCJC has been checked. Now, the question comes up from property managers, hey, I don't manage a single family property, I manage multi-unit properties. Do I need to go through this procedure? And the answer is yes, you should, because the form isn't exclusively about exempting single family properties. There are other notices required by the Tenant Protection Act, which should also be integrated into the rental agreement. It's a great law. Okay. So for every property you manage, you should have this form integrated into your rental agreements. Okay. Now I mentioned the TOPA, and I said before, you're selling a property using our RPA form, which is what you're doing when you're selling a single family property. Then you need to attach the TOPA, standing for the Tenant Occupied Property Addendum. The way you do that, you check the box on page 2 of the RPA and you just attach it. Now, there is a choice that the seller has to make. If the seller is selling the property subject to the tenancy, then that's the default on the TOPA. The buyer is taking the property with the tenant. It's like an investment purchaser, and that's the default option on the TOPA. You don't need to check a box to indicate that. On the other hand, if the seller is promising occupancy, that is, they're promising to deliver the property vacant, then the box under 1B, the box 1B should be checked, and that has the caption property to be delivered vacant. Now, in that case, the seller is now promising that they will make good faith attempts to remove the tenant, and that is the key here. The seller is only promising to attempt to remove the tenant. They are not making an absolute promise to remove the tenant, and this is really different from what was being done before. Before we reorganized our contracts in December of 2021, the overwhelmingly common practice was for the seller to make an absolute promise to deliver the property vacant. And if the seller couldn't do that, that was a breach. And the buyer could hold the seller responsible for damages, and sometimes those damages were significant. But now, with the TOPA, the seller is no longer making an absolute promise. I mean, if they can get the tenant out, great. But if they can't, then the seller's liability is limited or none at all. And this is why you, especially as a listing agent, need to make sure the TOPA is attached. So what happens when the tenant doesn't vacate? So we assume a TOPA, we assume the box promising vacancy has been checked. Now we assume that the seller has made good faith attempts to get that tenant out, but the tenant's not vacating. What happens? And in that scenario, there's two choices. The buyer may choose to close with the tenant in the property. And if the buyer does that, they have no further claims against the seller. That is it. They're done. They buy the property with the tenant. That's it. Okay. But the buyer may also choose to cancel. And in this case, the seller will be obliged to pay something to the buyer, but the amount is limited. So the seller is obligated to cover the costs of the buyer's inspections with an S, inspections with an S, meaning it could be more than one inspection cost, and the appraisal. Okay, but those costs are a lot better than the liability that the seller had been facing previously under the old system. So that's the point. In conclusion, attach the TOPA. Okay. Now, let's see here. I wanted to talk about this special federal law that requires a 30-day notice to vacate before a landlord may begin an eviction based upon non-payment of rent. So let me repeat that. Before a landlord may begin an eviction based upon non-payment of rent, this federal law requires a 30-day notice to vacate. And people are thinking, wait a minute, I thought it was a 3-day notice to pay rent or quit. And the answer is, it's not. It's not if the property is subject to a federally backed mortgage loan or participates in various federal subsidy programs such as Section 8. In that case, it's a 30-day notice to vacate for non-payment of rent. So if the tenant is behind on rent, you can't just serve a 30-day notice to pay rent or quit. You need to serve this thing called, sort of generally called, a 3-day notice to pay rent / 30-day notice to vacate. And so this is a federal law, believe it or not. But a lot of people are just not aware of it. and it applies everywhere through the state of California. I mean, throughout the entire country, it's a federal law. So just one surprising thing to be aware of. Okay. Anyway, so the last two slides here, I want to touch on this LA County moratorium and also changes in the LA City rent control law. So up until 4 weeks ago, this LA County eviction moratorium was a gigantic headache for sellers and agents in LA County. And as a practical matter, it made it illegal to terminate a tenant without fault in LA County, anywhere in LA County, even for single family properties and condos. Now, this eviction moratorium had applied to everyone in LA County, even if the property was located within a city limit, it was still subject to this rule. Now, it had been renewed several times. So when March 31st, that's the expiration date, when March 31st was approaching, I was thinking, a lot of people were thinking, it would just be renewed again, but it wasn't, and it expired. So since April 1st, there is no longer a county eviction moratorium in place. That is for most tenants. And that means if you have one of those exempt single family properties that I've been talking about, then the tenant can be asked to vacate on a 30 or 60-day notice using the old-fashioned rules of at-will tenancy. Okay. Now, there are limited protections still in place. The slide has this question, you can see it in red. What protections are being extended beyond March 31st, 2023? And the answer is that if you were a tenant who utilized the county rent moratorium rules between July 1st, 2022 and March 31st, 2023, then the eviction moratorium still applies to you. But this type of tenant will be pretty unusual. So for the vast majority of properties in LA County, the eviction moratorium has expired. So that's some good news. And then finally, I just want to talk a little bit about very recent changes to the LA City rent control ordinance. So just in January of this year, the just cause eviction rules in the city of LA, we're not talking county now, city, the just cause eviction rules, which were normally only applied to pre-1979 properties and never to single family properties and very rarely to condos, those rules, those just cause eviction rules now apply to all properties anywhere within the city of LA, including post-78 properties and including single family properties and condos. And now you might be thinking, wait a minute, I thought Costa-Hawkins exempts single family properties from rent control in localities. And you're right, it does exempt single family properties from rent control, but it doesn't say anything about just cause eviction rules, right? So the landlord in LA City, even of a single family property, is free to raise rent, but the landlord is not free to terminate for any cause. Now, San Diego City has a just cause eviction law like that too. And so I'm telling you this because we're seeing more and more rent control laws and stricter rent control laws. And I'm just wondering if more cities are going to adopt these types of rules. I don't really have to wonder because I was just reviewing an ordinance, which I think has yet to be adopted by the city of Pomona, which is adopting a pretty harsh, pretty strict rent control rule, but it's going to come with a relocation fee if you ever are able to terminate without fault. It's going to come with a relocation fee of up to $23,000. So that's just an example of the things that we're looking at. Okay, so I think that's my presentation. Let me put myself on mute here to get rid of this beeping sound. How do I do this, please? How do I do this? There must be some way of putting myself on mute. I'm sure. How do I do this? Let me think. Oh, I stopped share. Maybe that's the key.
There you go.
Okay.
All right, perfect. Thank you, Robert. About as clear as mud for those of us that don't do property management, I'm sure, and clearly important for us to stay up to date, which is why everybody is here joining us this morning. There will be an opportunity later for questions for Robert, so if you joined us a little bit late, just want to make that clear. And then a couple things I'd just like to comment on before I introduce our next panelist. First, some of you guys may be asking, well, why are we talking about stuff that's specific to LA County? First one would be if you have any clients, obviously, that are working in or around LA County, that could be important to us. But also, and really from the legislative side of things and the policy side of things that come out of LA County, San Francisco area tend to bleed over into other areas. So if we're not really keeping an eye on what's happening in some of these cities, things can end up in our backyard quicker than expected. So it's definitely something worth noting. And as Robert mentioned, some of these more local ordinances are starting to show their head a little bit more, and something that we continue, your government affairs team continue to monitor and fight on your behalf. Thankfully, knock on wood, right now, we don't have very many cities in our area, if any, that are pursuing these, but we know it's a very hot topic. In fact, there are multiple pieces of legislation currently being proposed with some sort of attack on either rent control itself. We've got Costa-Hawkins being attacked. It just seems to be constantly a battle zone area. So wanted to mention that. Also, for those that have heard me talk before on some legislation, I just want to draw some clarity here. We use acronyms like crazy. You guys all know that. You're familiar with that. But there's one in particular that Robert mentioned, TOPA, which is the tenant occupied addendum that he was talking about. Or you've heard me talk about TOPA as the Tenant Opportunity to Purchase Act, which is legislative policy that we are opposed to, that is showing its face in some of the other counties in the area. So I just wanted to draw that distinction, that if you're hearing that term TOPA, make sure that you're definitely clear on if you're talking about that form or what we're looking at from the tenant side versus a policy that would have a negative impact on home sales. And if you have questions about that in particular, feel free to let me know or get clarification later in the program here today. So with that, Robert, thank you again. We are going to move on to our next presenter here. How many people on the call are aware of any legal challenges surrounding the MLS and CRMLS? And if your hands are not raised, I don't know where you've been living lately, because they are all over the place. We've seen them all over social media, all over news. We've tried to do a good job of getting the information out to you guys. And as such, we have invited the attorney for CRMLS, Ed Zorn, who most of you know, but if you don't, Ed's a phenomenal attorney, great friend of our association, and we've asked him to give us some updates on some of those legal challenges in the MLS world. So with that, Ed, I will turn this over to you.
Great, appreciate it, Alan. Thanks a lot. Always like the opportunity. Wish I could be there in person with you guys. Always like coming down into Temecula, maybe sometime soon. But I'm going to talk a little bit about some of the challenges that are facing organized real estate, and specifically some lawsuits and other potential federal regulation and action that's going on related to the multiple listing service, right? And so anytime we're talking about the multiple listing service, Art Carter, our CEO, myself, when we go out and talk, we always remind people of what is an MLS. Some people think an MLS is an advertising platform. We're here to help sellers sell properties. That's not what we are. Some people think an MLS is a technology platform, kind of a company that exists to give agents technology to help them. While we do a lot with technology, also that's not our core mission or what we do. What the MLS is a broker cooperative. We exist to help brokers cooperate with one another to represent their clients in getting properties sold. And that means moving a lot of information, and it certainly involves a lot of technology. But at its heart, the multiple listing service is a broker cooperative. And right now, there are a number of lawsuits that are challenging some of the long-standing rules and processes that the MLS has used over decades in fostering that cooperation. And so I'm going to walk through those lawsuits, and then again, you can put, we'll be taking some questions a little bit later. The first of these are really two different lawsuits that involve and have been brought by those who are sellers. So owners of property that listed their property for sale with listing agents. And the first of those is called Sitzer Burnett. It has two names. It is based out of the state of Missouri. It is a federal case. And in this case, the sellers are arguing that they overspent in commissions in the amount that they paid the buyer's commission. Their argument is, as the seller of a property, they shouldn't be involved in a system or a process and should not be subject to rules within a multiple listing service that requires that they pay the buyer's agent's commission. The idea is, if the buyer wants someone to represent the buyer, let the buyer pay it themselves. Why are we, as the listing side, as the seller, being required under this historic system of rules that the MLS has put together from NAR, required to make that payment? And a lot of it goes around transparency of commissions, who's getting paid what, lots of confusions to the consumer. And that's kind of the basis of that argument. They have sued NAR, the National Association of Realtors, as well as four, we call them the corporate defendants. It's, Remax, Keller Williams, what is known now as Anywhere, previously Realgy, and Berkshire Hathaway. They sued the corporate entities, so not individual franchisees, but the corporations. And their argument is that these groups of people, along with NAR, got together and they created a system that keeps commission rates elevated in this way, because instead of each side paying their own, we share this commission inside the MLS. So that's kind of like the heart of their argument on the seller side. That first case, Sitzer Burnett, has been around now since 2019. We're not at the beginning of this. We're coming to the end of this case. It has been recently certified, or actually last summer, it was certified as a class. And then in October, the court denied NAR's motion for summary judgment. And in that case, in that hearing, NAR and the corporate defendants moved for summary judgment, and the summary judgment is very hard to win. So it's not surprising that NAR lost, not that big of a deal. But there was some language in the ruling that the judge made in that rejection of the motion for summary judgment, where they said that the case would be handled in what we call a per se manner versus a rule of reason. And if any of you have been around for some time, you've heard NAR and local associations kind of make the pitch of, while we have rules requiring compensation in the MLS, those rules are worth it. While it's a small burden, because the overall commission rate is fully negotiable, as John had said earlier, there is a small restriction on trade, but the benefit we get is huge, right? There's this concept of the MLS and the MLS agents working together to make sure that any buyer can see all of the properties in a region that are available, right? It on net is a huge benefit to the consumer. And so it's worth that tiny little reduction in potential restriction of trade. That's called a rule of reason argument. And you balance, right, the benefits to the consumer against the challenges to the consumer. In that motion for summary judgment denial, the court said that's not the rule we're going to follow. We're going to follow a per se standard. And in a per se standard, when you go to trial, the court is only looking for any restriction on trade. And if the plaintiffs prove any level of restriction on trade, then it goes straight to damages. How much were you hurt? You don't engage in this balancing. So that's not a good decision. I think it's an error by the judge. I think the judge made a mistake on that. I think if we appeal that part of the case, that we should prevail on an appeal, because that was definitely a wrong ruling by the judge. That case right now, though, is set to go to trial this year, October, right? So we will have a ruling in this case, by the end of the fall. And so that is not far away. There's another case that literally has almost the exact same fact pattern. The sellers are making the exact same arguments that they overpaid commissions by paying the buyer side. And this case is called Morrell versus NAR, exact same defendants. It's also against NAR, the 4 corporate defendants. This case is a little bit behind in time, but just recently, a couple months ago, the court did approve a class certification for the Morrell case. And class certification is where you have to put evidence in front of the judge, and it's not putting up your whole case. And it's not that Morrell won the case. NAR still some good arguments on some facts in the law that they shouldn't be held responsible. But what the court ruled is that this is a case that is appropriate for certifying as a class. Now, they certified 2 classes in the Morrell case. And in Morrell, this is filed in the Northern District of Illinois, but they specifically identified 20 separate MLS markets across the country. So this is more a nationally styled base action. Now, none of those 20 markets are in California. So at this point, we don't have a California-centric case, but this larger case in 20 different markets, in the class certification, they certified a damage class of all sellers from basically 2015 to 2020. And the experts have an opinion and put it out in front of the court. $13.5 billion. That is with a B. $13.5 billion is the damage claim in that case. I anticipate that that case will probably go to trial about this time next year. I would expect over the summer that NAR will also bring a motion for summary judgment, and I also fully expect them to lose that summary judgment motion. I don't see there's any shot at that being, NAR being able to win that. So that, again, not a surprise if they lose that motion. That's normal to lose those kinds of motions. So that's the Morrell case, very large, case, very significant ramifications. There's also a third class action lawsuit. This is also in front of the exact same judge that has the Morrell seller side case. And this one is brought by the buyers in a transaction. And this argument goes like this. The buyers are saying, look, I'm the one who paid the commission as the buyer, right? I'm the only one who brought cash into this escrow. I'm the only one who put money in here. So why is it that a seller gets to negotiate with this person called a listing agent, none of whom I have a relationship with, and why do they get to set the fee that I have to come into escrow and pay to a buyer's agent? Right? In other words, if you think about the process and how it works, what relationship does the buyer have in negotiating the fee that the buyer ends up having to pay for the commission? Now, the good news of that case from a legal perspective is there are some standards in the antitrust law that says an indirect purchaser doesn't have standing to sue. And we're also benefited in that it has the same judge as the Morrell case on the seller side. So she has written a couple times recognizing, hey, both the seller group over here in Morrell and the buyer group over here in Leader are asking about the same pot of money. Well, they can't both have been damaged over the same pot of money. It can only go to one of them. So what she has done in the past is she has dismissed that buy-side case. The plaintiffs have tried to kind of redraft their complaint. NAR brought a very strong, very good motion to dismiss, and we're pending the judge making a ruling. I'm actually very surprised she hasn't made the ruling yet. It could come any day. I do anticipate that she is going to dismiss that case and kick it to the curb and end that case. And that will be good for NAR and all of us if that case ends, right? So that's kind of the commission cases, kind of what's going on with them. One thing I've read a lot about, and I've heard people comment on when I talk about these cases is, well, there's certainly been problems in the rulings in the case, which I agree with. And there are definitely things that NAR and the corporate defendants can appeal. I agree with that. And I think they'll win on appeal. Totally agree with that. I think there have been mistakes made by the courts moving through this process. And so people are saying, well, then since we're going to appeal, right, this is going to be like 4 or 5 years down the road by the time all these appeals get done and all that. And that's probably right. Maybe more like 3 to 4 years before this gets resolved. However, there is a federal rule, Rule 62 in the Federal Rules of Civil Procedure, that don't assume that because the case gets appealed, that the plaintiffs don't get to go after their money. An appeal does not stop what we call execution of the judgment. Right? So even though there's an appeal pending, the case is only stayed for, under Rule 62, 30 days. Defendants get 30-day window to not have to pay. On day 31, they owe all the money. Now, you can get a stay pending an appeal. You got to bring a motion to the court, and most of the time, you have to post a bond. Traditionally, the bond that you have to post is for more than the judgment. So guys, if this is a $13.5 billion case, let's say it only goes to a $3 billion case. Anyone here want to post a $3 billion bond? Right. So I'm just bringing that issue about just to make people aware that while there will be, in fact, appeals that may go forward, that we as realtors, boot on the street, may be subject to some rule changes or some modifications in what we do from these cases well before the appeals finish. Because one of the other classes of plaintiffs that the court certified in Morrell was an injunction class. So there was a second class, and that class is all current and future sellers of real estate. And that class was specifically formed for the purposes of imposing an injunction. So one of the things that these plaintiffs are pushing for is the court to issue an order that ends the sharing of commissions in the MLS, right? Make no mistakes about it. That's what these cases are about, is trying to remove the sharing of commissions inside the multiple listing service. So that's kind of their target. And unfortunately, they're not the only ones making that argument. We're also up against the Department of Justice has actually been investigating the same commission issue for a couple of years, along with the clear cooperation policy rule. Now, back a couple of years ago, NAR and the Department of Justice, after 2 years of negotiations, entered into a settlement agreement to resolve that investigation. And NAR agreed to modify some rules about transparency to the consumer, specifically about commissions. And here's the great news. We've already implemented those rules. Those rules are already part of the CRMLS rule set. NAR changed those rules a couple of years ago. However, in an unprecedented move, when we had a change in presidents that maybe some of you recall a couple of years back, the DOJ reneged and breached that settlement agreement. And they withdrew, and they immediately started those investigations up again that the DOJ promised to not move forward with. And that was a breach of the settlement agreement. And so NAR did a very admirable job, made some very strong and articulate arguments where the NAR actually sued the Department of Justice, and demanding that the court, the federal court, enforce the settlement agreement. And NAR prevailed. NAR won. And that was great news. That was a few months back, towards the end of the year. Great win for NAR. But the DOJ has appealed that ruling. So that is now up on appeal because the DOJ wants to investigate this exact same issue about how we share commissions. And because that's not quite enough, the federal government also has, after Biden took his role as president, he issued an administrative order amongst a lot of things. It's like a 75-page document where, buried in that document was a sentence about this exact same issue on how we share commissions inside the MLS. And Biden directed the Federal Trade Commission to look at their rule-making ability to determine whether they should issue rules with regard to this same issue. So that is kind of the whole cornucopia of attack that's happening that Adam referred to earlier with regard to how we share commissions on the MLS. Now, after saying all of that, I'm also here to tell you that it's actually not that big of a deal. It's really not. The value proposition of the MLS is what I started with, which is cooperation, right? We're a broker cooperative. And what makes the MLS strong and what provides you the necessary tools and mechanisms for you to do a great job at representing your buyers and sellers is the fact that we cooperate with one another. So anyone here do commercial transactions? I got my CCIM designation in 2006, right? So if you've done commercial transactions, one of the things you know is there's no MLS. You know what that also means? There's no sharing of commission in the MLS. That means you have to negotiate when you're representing a buyer. How are you going to get paid in this transaction? And so almost all of us that have done commercial transactions for the last couple of decades, what do we have? In our letter of intent or in the offers that we present, we have a section that talks about the seller, not the other agent, but the seller themselves paying a portion or all of the commission that I'm entitled to based on the contract I entered into between me and my buyer, right? And guess what? I've closed over 200 commercial transactions. Guess what? I've gotten paid on every one of them, and not one of them was in a multiple listing service, right? So this is not groundbreaking, earth-shattering event, right? It is easy to get paid a commission that you've entered into an agreement with your buyer on inside of a real transaction. Guess what? Almost all of those things happened also. They all got loans, right? And in fact, Northwest MLS, which is the predominant MLS up in the Seattle area, 35,000 members in Seattle. They're not an NAR affiliate MLS, meaning they don't have to follow any of these mandatory rules like CRMLS does. And last October, they removed from their rule set the sharing of commissions inside the MLS between brokers. Now, any representation in the MLS about any offer of compensation is made directly from the seller to a buyer. And they modified their residential purchase agreement so as to accommodate that negotiation right in the document. And I just got off the phone with one of their key lawyers today. John, I haven't even shared this with you yet. I participated in a PAG with them over the summer, a presidential action group, talking about legislation at the Washington state level to mandate buyer broker agreements. And if you recall, there was a point in time where California was considering this. It has passed both houses of the legislature. And based on my conversation about 2 hours ago, I'm anticipating that'll be signed by the governor of Washington today. So, in pretty short order, Washington state will be mandating buyer representation agreements to do a transaction. Now, the reason that matters is that assists in this concept of not having the commissions run through the MLS, and it also enhances buyer transparency, right? That now the buyers will be directly negotiating with their own agent how much they're going to get paid. And then you just make that amount just like you would a repair request or a termite in your repairs or negotiating for something like the refrigerator, right? That just becomes some other element to negotiate inside of the transaction. And they've been having this process go on since October, guys, and they get deals closed. VA properties get closed, right, from lending with this process. So I'm here to tell you, while we have these challenges against commissions in the multiple listing service, I'm going to tell you at the same time that if we lose commissions in the MLS, it's really not that big of a deal. It is a completely fine solution as long as you guys are getting buyer representation agreements signed. It becomes a big problem if you're going about life without a buyer rep agreement before a showing. You guys need to get into the habit of signing buyer representation agreements before you ever show a property. John knows this. I argue that's already mandated under the Code of Ethics. I've always taken the position that Article 9 mandates that you have a buyer rep agreement before you show a property. It doesn't say it in that way, but I can make a logical argument to defend that position. So it's something you should already be doing as a professional. I know it's not done commonly, but I can tell you that in many other states, this is the norm. I practice here in the state of Tennessee, and I've never shown a property without a buyer representation agreement being signed, nor would anybody in this state even contemplate that as an issue, right? It is par for the course that is signed before we show property. And that's the norm. And in fact, about 50% of the transactions in the country have a buyer representation agreement signed, right? There's just certain states and cultures around where it's not done normally. And so I encourage you guys to get used to that. CAR did an excellent job. And I thank those of you that may have participated in that work group and committee, that they really did a fantastic job of updating the buyer representation agreement. It's a very easy form to use, very well worded, gives you lots of rights, and something you should all get very comfortable, with using and doing. But that is by far kind of the biggest issue that's happening now in the MLS world. Things are going to change. That's what's going to happen, and it's fine, right? It'll be okay. And some of the other things that CRMLS specifically is doing to get ready for this season of change is we're really kind of doubling down on this concept of cooperation, knowing that we want to make sure we deliver to you the proper technology and mechanisms to enhance that cooperation. So you guys are all going to be getting emails super soon about our rollout of the RE Center Hub. That's a new dashboard interface. It is a product that was completely developed, engineered, and coded by CRMLS. It is our product. We made it. We took into account information from brokers and agents like you in creating our own product. So we're not going to rely on an outside vendor to deliver some of these services. We're trying as much as we can to bring some of that stuff kind of in-house. And that's going to be rolling out here in mid-May. Will be happening. And so how you interact with logging in, it's very customizable. You'll have a lot of ways to personalize it as far as statistics and putting the tiles that you use rather than just a giant mess of all the tiles, 80% of which you never touch. You can put the ones that you want to see. It enhances communication mechanisms from your association. So Southwest Riverside will be able to communicate with you better. And we're also rolling out a new compliance platform that we've designed that will enhance some communication and opportunity for you to interact with compliance, through these processes. So that's probably the summary. I could talk probably for 2 hours just on legal issues going on in the MLS world and some other things that are afoot. But I think that probably covers most of the main topics, Adam.
All right, Ed, thanks so much. I did put in the chat, guys, we will have an opportunity for some Q&A. If you want to start typing some of those in, feel free to do that. We'll get to those after John's presentation. Ed, thank you so much for your presentation. Obviously stuff that our board of directors has been talking about and discussing for quite some time. And while there's arguments obviously on both sides, and I'm sure opinions on both sides, I think the one thing that everybody could agree on, which you hit at the end of your presentation, is that some sort of change is coming. And how we embrace that change and how we prepare for that change will really decide how successful we're going to be moving forward. So getting this kind of information is crucially important. So I appreciate that. I also want to note for all of our guests here that may not have seen John's video, but as Ed was talking about the buyer representation forms and encouraging its use, John was thumbs up and applauding. He's never been shy about that, but I wanted to make sure that you guys were aware that he continues to support that, and there's been a lot of work around it. So, Ed, thank you very much. I'm sure we'll get to some questions for you as well, but I will now introduce. I thought I was going to get him back, so I will introduce the new president of the Las Vegas Raiders Boosters Fan Club, your association attorney, John Giardinelli.
Well, the good news is that the Raiders will be drafting early because they had an incredible losing season last year, as has become quite typical regardless of where they play. And they play pretty much all over the place. I think they're still in Vegas. I'm not sure if they've moved yet. Well, I agree with what Adam and what Ed said regarding the fact that change is coming. I personally, as most of you know, I've represented this association for well over 25 years, and I represent 11 others, and we're just seeing tremendous change. So I want to just say a couple of things real quickly. Number one is both Ed and I live in Tennessee, and in light of Robert's talk regarding the complexity of landlord-tenant, if anybody needs a good realtor here in Tennessee to refer business to, let us know. I also want to parrot what Ed said. I live in Tennessee. I've purchased some rental properties, and my wife actually is on the road right now with our local realtor, because my best friend and his wife are moving here, and they're looking at a particular piece of property, and they've already signed a buyer representation form. You just don't do real estate here without a buyer representation form. Just like you wouldn't hire a lawyer without a retainer agreement. You wouldn't hire a doctor without some understanding of what the building's going to be. When you go to the car dealer to get your car fixed, you get an estimate in advance of all of the costs that you're going to incur. It's what professionals do. I'm going to be coming into California, and I'm going to do a live brown bag, and we're going to go deep on all this stuff on May 26th. Now, because I have to catch a plane to Maui that afternoon or that evening, we're going to do it a little earlier than we usually do the brown bags. We're going to do it at 9 o'clock in the morning. But we're going to be able to go till at least 11:30, maybe even noon. If there's a lot of questions, I don't know how many people will show up, but we're going to cover a deep dive on not only the form that I'm going to mention, but also on all the forms that are coming out in June. And we'll talk about a whole bunch of other stuff, cases and some new laws and what's going on. So as Ed mentioned, we are heading toward a time, I believe, when a buyer representation agreement will be mandatory. Article 9 of the Code of Ethics does require all agreements to be in writing. So whether that will be by legislation in California, that's always an iffy product because of the legislature that you guys have. But I believe that we're already getting close to the point where not having a buyer representation agreement is below the standard of care. Now, that's my opinion. It's not the law, but I believe that if you don't have something in writing with your buyer relative to how you're going to get paid, what you're going to get paid, under what circumstances you're going to get paid, I think we're quickly approaching the time where that will become a reality. You know, I don't want to hear about, oh God, everything is changing, and oh my goodness gracious. You've been under a series of changes for 20 years. You know, you went from books to computers. You went from small MLSs to the largest MLS, I believe, in the country or the world, which is Ed's MLS. You've gone from brick and mortar offices to virtual offices. You've gone from all kinds of different ways of doing business, but the same basic code of ethics still applies. The same basic relational issues still apply. There is a new BRBC form. That form, I believe, as Ed said, is excellent. It is a form you can use as a way of setting up an exclusive representation, or simply indicating that this is how you will be paid if you are involved in some way with the property that is ultimately purchased. What I'm gonna do on May 26th, I'm putting the form up on, and we're gonna walk through it, right? Things like, how do you set price? Well, you better set it fairly carefully, because if you do what I've seen some people do, $1 to 5 million, it's not going to be enforceable. If you want to talk about geographic area. You know, there are different ways of designating, but if you put Southern California, it's real possible it's not going to be enforceable. So you want to make sure that you understand, and I'm going to literally put one section up at a time and walk through it. I've done it a couple of times, it's a lot of fun. It also is going to help establish whether or not if you work with, I've heard this a million times, I worked with the buyer, you know, we did all this work and I showed them all around, and then they ended up purchasing a property that I showed them, but I didn't get paid because they went from me to another broker. Well, when that happens, and if you believe you did enough to procure a buyer, which is what Ed's organization is helping you do by putting these listings in and cooperating, then having a written agreement is going to go a long way in order for you to establish that you were involved in this property. The California Association of Realtors, approved by NAR, changed their procuring cause guidelines, which hearing officers use to decide who gets the pot of gold in a dispute between broker number one and the closing broker, whether that's the listing broker or another broker. And they've used a couple of phrases now that we've had some really interesting conversations at your board back in February about. One is that a person who has a broker representation agreement in writing executed by these buyers on a property that they were substantially involved in, which is defined in the BRBC, they are going to be given great weight in terms of determining whether they are or are not the procuring cause. And if that happens, and if the panel believes that they are in fact the procuring cause and have a written agreement, that's going to really tip the scales in a lot of cases. I've been in a lot of hearings where it really was so close that the panel couldn't decide, and therefore the respondent wins because the complainant has the burden of proof. But now you put into play the fact that you have a written agreement, that the property that was purchased fits within the description of that written agreement, that you did your job, that you were involved, that you kept in touch with your client. That's going to go a long way in establishing that you in fact were the procuring cause. And I'm going to go through, and again, I don't sell real estate, I'm just a lawyer, but I've talked to some really top-notch brokers, some of whom are in Southwest, and one of whom is not in Southwest, but was on the broker panel that came up with all this. And I've come up with some best practices that I plagiarized from real brokers. And so we'll go through all that. I'll see y'all on May 26th. I have to pull out my slacks. I have no idea what I did with them. And I will be wearing long pants and shoes that day in honor of Connie and my concern for her. As Ed mentioned, there's also some changes already underway. For example, in a revision to the RPA, which took place in December, and there's going to be another revision coming up in June, what they've done is they've said, look, if you do have a buyer representation agreement and you are to be paid a certain amount of money and the offer of compensation in the MLS does not quite get to that point, and I'm just picking a number just for conversation. Let's say that you're agreeing with your buyers that you will be guaranteed 2.5% if that's the way it's going to work, and the offer of compensation in the MLS is 2%. Well, that leaves a gap of 0.5%. If that's the case, they've modified the RPA, and as Ed mentioned, just like you would ask for closing cost or some other closing related cost or repair cost or a credit for some other thing, you can now ask that the seller agree to make up that difference. You have to have a BRBC. You have to have a new form, which I'll show you down the road, which is online now. And you would then send all that to the broker with your offer. And in the RPA, you would now check off box, I believe it's 3G in the matrix, and you would just ask. It's not mandatory. The seller can say no. There's all kinds of counters that can go back and forth, but at least you put it on the table. Hey, will you make up the difference directly through the proceeds? And so that's now out there. And I'll go over all that with you. There's going to be a whole bunch of really, Neil and his gang at CAR did a bang up job with the forms, and there's going to be a whole bunch of, there's only going to be a couple of new forms. One which I'm guessing Robert had a lot to do with, which is a cash for keys form, which is actually already available. They issued it early in April. And so there's that form is out now. They're going to be issuing a new form, which is a mixed use form. Yeah, if you're selling a property that has at least 1 to 4 residential units and commercial, and that happens periodically in Tennessee, it happens all the time, you still have to do an RPA, or excuse me, a TDS form on the residential. And so they're coming up with an addendum for the mixed use properties. And I've looked at it, and I don't know that they'll make changes. I can't show it to you today, but I will be able to show it to you in late May. And it's really a fine form. In addition, there's going to be a whole bunch of revisions. I'll go over them, and we're going to do a newsletter next month. So in conjunction with my brown bag, we'll actually cover most of the new forms. But there's going to be a very minor but very essential change, I believe, to both the TDS and the SBQ. Right now, you have a TDS form that, and it's very confusing to some people. Should I use this form for all 3 units or 4 units? Should I use it for, how should I use it? They're going to change both the TDS and the SBQ, and they're going to add a line right below the name of the form, and it's going to say this form is applicable to unit number. And this way, if you have up to the 4 units where you are mandated to use the TDS, you will be able to say this TDS applies to unit number such and so, and the SBQ will be the same. So you will be able to have both the TDS and an SBQ. Now, some of you are probably thinking, oh, wow, that much more work. Yeah, but a lot less work than responding to deposition notices, mediation notices. 80 some odd % of lawsuits and 1 out of 300 cases in California end up in litigation are disclosure related. So you want to have your disclosure docs in good order, and they are going to update a couple of other risk management documents, the statewide buyer advisory. They're going to update the disclosure information form. So they're going to do a lot of cool stuff. They're going to modify most of the listing agreements. I think all of the listing agreements. Most of you use the exclusive, and it's going to give you an opportunity to have in the contract an instruction from your seller. Provide me with the offers as they come in on a chronological basis, but there'll also be a place for you to elect that you can have your seller instruct you, hold the offers to a certain date, and then we'll go over all of them at the same time. This way, you can make that call with your client if you so choose. There's also, and I have 2 major cases going on right now where someone belongs to a team and they have a poorly crafted or no crafted team agreement, or their team agreement is not current, and now a party leaves the team and now claims that they're entitled to compensation for transactions that closed while they were a part of a team or in some other manner. And they're going to make some really nice changes to the team agreement form that will cover that. And in addition, there's going to be a whole bunch of other changes. They're going to make some changes to the notice to buyer to perform. like I said, we'll go over all that with y'all in May. Ed and I, a week or so ago, did a panel, and on that panel was the assistant commissioner from the Department of Real Estate, who's in charge of legal affairs. So real quickly, just a couple of things that he mentioned. Number one, they're in business not to help you, but to help the public. Their number one charge is protection of the public. Their top issues right now are misrepresentation and dishonest acts. So those of you that don't present all the offers that come in to your clients, be aware that may be your retirement transaction. Because if in fact the Department of Real Estate finds out that you acted dishonestly with your client in some fashion, and this was one of the things he talked about, you may be surrendering your license. Advertising issues. I am updating, I keep saying it, and hopefully we'll get it done within the next couple of weeks, but I will be updating our advertising guidelines, which is already offered on your association's website. A big jump in unlicensed activities. And that seems to coordinate with the fact that we're seeing much more involvement now with transaction coordinators, some of whom are unlicensed. And again, if you're unlicensed, there's things you cannot do. And so the DRE is very sensitive to that. The other area of unlicensed activity has to do with rentals, a property management, Robert's field. And that is because if you are doing property management, you must have a broker. And a lot of agents are setting up their own little property management divisions without broker supervision. Sitting an open house for another brokerage is really something you need to be careful of. And I'm going to go into a little deeper dive on that because we're going to run out of time today. And then again, broker supervision issues like fair housing, issues like advertising, and not having written policies that agents can follow has become a really big issue. And then lastly, and I'll finish with this, Adam, just the calls that I'm seeing, a lot of calls about incomplete transfer disclosure statements, right? A transfer disclosure statement is not deemed delivered and finalized until it is complete. One case, let me give you a quick example. We got in one where the seller sent over the transfer disclosure statement, and in the section they were supposed to fill out, they put avid form to follow. Well, that means the TDS is not complete and the buyer continues to retain the right to cancel. We've had a lot of deposit issues. Just be really careful about deposit issues. It is inherently a legal question. Obviously, we're getting a ton of calls on the buyer representation agreement. We're seeing, and statistics seem to bear this out, I believe CAR, and I don't know how they did it, but they have these magical ways of finding stuff out, reported that over 60% of buyers in the period that you all came out of recently were not happy. Now, unhappy buyers equal what? Unhappy plaintiffs. And so we're kind of monitoring issues like what happened with non-contingent offers, with issues like using escalation clauses, and CAR's got some great quick guides on all that stuff, and a new advisory for non-contingent offers. A ton of information and calls on issues of dispute when there's a dual agent. NAR insurance says it is the #1 way you can get sued. If you're a dual agent, you have dual fiduciary responsibilities. That means your heightened obligations to both sides. And then lastly, we finally have a case, thanks to CAR and some very fine lawyer work. We've always wondered, we thought, based on federal law, even with the attacks on Uber and Lyft and all those, that realtors were independent contractors. And there was a lawsuit filed by a gentleman by the name of Whitlack. And in that lawsuit, he claimed that he was an employee of the franchise that he worked for. And the trial judge said no. It went up on appeal. CAR was an amicus, and the court, in a published opinion, so we actually finally have a piece of law, and it says, no, if you have a written agreement with the broker, which you have to have, and it's current, if you work on output, which is a fancy way of saying commission, and if you have a license in place, a salesperson's license under a broker's license, you are presumed to be, and it's a heavy presumption, very hard to overcome, you are presumed to be a independent contractor. And so I'll go over a little bit of that, because a lot of brokers think they don't have the ability to force their people to take education, and that's absolutely not true, thanks to some legislation that was sponsored by CAR a couple of years ago. Adam, believe it or not, I'm done. I mean, like Ed and Robert, we could all talk for hours about all this stuff and so much more. I think, frankly, from our three perspectives right now, it's harder to decide what to talk about than what not to talk about. Ed mentioned that he could talk for 2 hours. I know Robert could have easily talked for 2 or 3 hours, and so I'll shut up.
No worries, John. Thanks so much. You've mentioned a couple times, hopefully everyone's got that date written down. I'm sure we'll continue to promote it, but May 26th, 9 a.m. live in person will be the brown bag update, where John will go a little bit deeper. For those that may not be aware, we're also having our business meeting in Sacramento next week. So I'm sure there'll be some updates, I'm sure, coming from there as well. So this time we will open up to Q&A. I see a couple of questions already being put in the chat. Feel free to continue typing those. One, I'm going to start with here, John, just because you briefly touched on or mentioned here dual agency. There's a question in here relating to the cooperative compensation in the MLS. And the question basically says, if the buyer's having to pay for their own agent, would they then not be encouraged to go directly to the listing agent to try to avoid having to have that negotiation with the buyer side? What's your opinion on that with dual agency? And I guess it could kind of be teed up for a little bit of Ed if he has some comment on that. But do you anticipate some of these changes then promoting a little bit more dual agency?
I hope not. I don't think dual agency is necessarily good for the consumer, and hopefully NAR, and they have some incredibly fine lawyers working on this. Hopefully that's one of the issues they'll be able to sell, is that if we end up pushing our way towards dual agency, that's not necessarily going to be good for consumers. I will tell you that there are, and you know this, Adam, because you're participating, and of course Ed is leading a lot of the discussions. There are conversations going on everywhere over, okay, if in fact the issue of buyers having to pay directly becomes the norm, which many of us think it probably will be, then what happens to first-time home buyers who can't afford to come out of pocket and all that? And these conversations are taking place everywhere. I can't really go into a lot of detail. I don't know if Ed wants to, but I, it's like everything else that's ever happened. No one is going to be caught by surprise. I think that, like with what's going on with the Northwest, what Ed's doing at CRMLS and all the things he's doing to anticipate. I know I had a conversation with Robert's boss last week, June Barlow, and I know lots of people. That's the reason I'm going to be in California. We're going to have a meeting at CAR, and I'm sure some of this stuff is going to come up. People will have ideas to present before all this, I know, for want of a better term, hits the fan. I don't like dual agency. I know Ed, you and I have had this conversation. It is very almost, well, in Williamson County where I live, you don't see it. You don't see dual agency here. I don't believe it's against the law in Tennessee, but you just don't see it. And there's lots of reasons for it, because you go from being an advocate, in my opinion, and in the opinion of some of the professional standards hearing officers, and I spoke with over 100 of them while I was in California, You go from being an advocate for your client in a lot of ways because of the dual fiduciary nature to becoming nothing more than a messenger for your client, right? Well, let me go check with the buyer. Let me go check with the seller instead of negotiating with the other broker. And I just think that you really narrow the ability to do a good job. That's my personal opinion. I don't think we're going to see dual agency become outlawed in California because from what I've been told, the trial lawyers love it, right? Because now you got two fiduciaries to sue, right? And so, no, I think there's going to be some ways around some of these issues that are being discussed right now. Ed, what do you think?
Yeah. So first off, that already happens, right? So as a question, anyone here ever have or work with a buyer maybe at the beginning of the relationship who thinks they can just go to the listing agent and get a better deal anyway? It's not like that doesn't already completely happen, right? And again, we're not saying if buyers have a contract. Again, in commercial, it's exactly how it works. I have a contract with my buyer for my buyer to pay me a certain percentage. Then I go to the transaction and I ask the seller to pay that amount. How is that different than what we do right now? Right now, isn't the seller, where anyone look at a closing statement when you were as a listing agent? How many of you see the fee going to the buyer's agent on the seller's side of the closing statement? Anyone ever see that on a closing statement? Commission, right, on the seller's side of the chart? It's going to show up in the identical place it does now, right? All you're talking about is the contracting at the beginning is different. So that's a risk you have today, where buyers have this misconception that if they go to the listing agent directly, it'll be better served and it'll be a cheaper deal for them. Again, that may happen a little bit at the very beginning, but I think in the long run, you're not going to really see that. And I can tell you, as a big problem, I can tell you Northwest MLS that has been under this system for 6 or 7 months, they're not seeing any kind of increase in their dual agency representation.
So Ed, on those notes, and we've had this conversation before also, but there's a few comments here in chat about the challenges that buyers already face, whether it be loan fees, down payment, or interest rates. If they're now having to potentially pay for their buyer's agent, does that then put more pressure on them? And I know you've mentioned, well, that's part of the negotiation, like you mentioned in a commercial transaction. But if you're in turn then asking the seller to help offset that, are we not where we're at right now?
I think that's the point, Adam. We're exactly where we are right now. So let me use an example. And again, like John, I'm not saying these should be these standard rates, right? But today, let's say you went, Adam, and you secured $1 million property to be the listing agent. And you negotiated 5% as your listing agent fee. And you have the communication with the seller to say, hey, look, under our current system, we have this MLS. We're going to have to put in there. I'm going to have to share. I think we should do a 5% offer to attract a buyer's agent. So you sign a contract for a 10% commission. You're going to split 5% to the buyer's agent. You're going to keep 5% on $1 million property. Let's assume there's no other cost, just to make math easy. Seller leaves with 900 grand. Adam, as a listing agent, leaves with 50 grand. Buyer's agent leaves with 50 grand. How is that different than, Adam, you go and you take a listing and you explain to the seller, hey, seller, my fee is 5%. There's a chance that a buyer's agent is going to come along and want to share in that fee. So be ready for that. So now you list the property for $950 because you realize seller's leaving with the exact same dollars at a $950 list price. I come in with a buyer and I say, my buyer needs a loan. It's a 100% deal. I was able to work this financing out. And okay, Adam, in the offer, I want the seller to pay my $50,000 fee. So we'll make the list price $1 million. And let's close escrow. What happens at the close of escrow? Seller walks out with 900,000, Adam walks out with 50,000, Ed walks out with 50,000. Oh, and by the way, when you talk about appraisal concerns, the house still closed at $1 million, just like it was under the other system. You realize there's no appraisal problem because every lender understands this is already happening. So how is that different? What I'm suggesting to you is it's not different. It's just how we organize it and what we're used to doing. But there's no additional risk to the lender. There's no additional risk to anyone else in the transaction by simply letting the buyer negotiate the fee directly with the buyer's agent and then wrapping that into the cost of the home. It's what we do today. We just do it inside this thing we call the MLS.
Right. And like you mentioned earlier, you know, that's just a change in how business is being done. That's just one of the more common concerns, you know, that I hear. Probably the most common concern is what's the impact going to be, particularly on first-time buyers. So, you know, it's going to, like everything else, I think if it goes that route, it's about education. It's about understanding the process, you know, before we get there.
Right. And again, I asked a specific question this morning when I was talking to the person I interact with at Northwest MLS. Right. And I asked, is there been any reduction in VA loans, FHA loans, anything like that? And he's like, no, there's been no reports of any of that kind of challenge or problem with this function. And they're doing it now.
Yep. And I know they're definitely the ones to watch. So thanks for that, Ed.
Again, we're in a, it seems like almost a perpetual transitory stage, right? And, you know, changes with property management. If anybody perceived that 5 years ago, we would be looking at, you know, landlord tenant, we're not even called landlords anymore. What do they call, Robert? Rental property owners. You know, where everything is in transition. The key, I think, is to keep track, stay informed. You're going to have to do that. Fortunately, you are all members of a board that does a phenomenal job of keeping you informed, but they can't make you read the stuff that they put on their websites, offering classes, etc. You're going to have to do that for yourself. And there's going to be lots of conversations. And when we come out of all this and go to the next major change, whatever that might be, artificial intelligence, who knows, we're going to, you know, we're going to have new sets of rules, standards of practice, guidelines, maybe even some code of ethics changes, who knows? So that's going to happen.
Yeah, I think the language on the the lease agreement was changed to housing provider in lieu of landlord. So landlord is nowhere to be seen in our lease agreement.
Robert, we got a question for you. Actually, just looking for maybe a little bit of a better definition or expansion on the 3-day notice, notice to pay or 3-day notice to vacate. So specifically, the question is, so does that mean that if they don't pay in 3 days, then they have 30 days to vacate? And would they have to wait the 30 days to actually start the eviction procedure?
That's pretty much exactly what it means. So the way the notice is understood here in California, it's going to be a 3-day notice to pay / 30-day notice to vacate. It is not a form that SRCAR has, but the idea is that following California law, if the tenant does not pay within the 3-day period, it is not incumbent on the landlord to accept any rent thereafter, but they cannot file that unlawful detainer complaint until 30 days has elapsed. Now, that's not completely legally for sure, because in fact, there was a case recently in Washington State where the judge said, no, it's, you have to wait. Basically, the tenant has 30 days to pay the rent, which would be a crazy result, but I don't see that result being adopted in California.
Great, thanks for the clarification. Ed, this would be a question for you. You mentioned in the Morale case that received the class certification, that giant $13.5 billion price tag. And other than you and John, No one has $13.5 billion probably to settle that case. So what would happen if that were to go through? Who's stuck with that bill, and how does that affect us both as an association and then us as individual agents?
That's a great question, and that's a lot of to be determined, right? There's a lot of strategy that goes around with that. I personally think that the most likely outcome of these cases is going to be some kind of negotiated settlement. That's what happens in virtually every class action case. Once it gets certified, almost none of them go to trial. They usually all get settled before. And I actually don't think a settlement is really that hard. It's one thing, and John knows this, being a litigator, it really doesn't matter what I asked for. It only matters what I can collect. And so you're correct, right? $13.5 billion. It can be $150 billion or $5 billion. What does it matter? That's just a hang on your wall as a lawyer, because you're never collecting that, right? The question becomes, what can you collect? And with the current defendants that they've named, which is just NAR and these 4 corporate defendants, they're going to get nowhere near that, right? So that lends itself to some kind of the parties coming together, maybe NAR or agreeing to modify some of these mandatory rules so as to allow for what Northwest MLS is doing in a more logical way, that way. And then putting up some kind of a number where NAR can, maybe do a special assessment spun out over, 3 years or something. And just realize, guys, with, 1.6 million realtors, you realize with $1,000 from every realtor, that ends up being 1.6 billion. And if you spread that out over 3 years, and if some of these corporate defendants and you break that money up into different groups, you're probably talking potentially just a couple $100 each to make it go away. That's what I'm saying. This is actually a case that can be settled. I've heard people out there going, "Oh, it's such a huge number, it can never be resolved." Well, every giant class action case that has ever been brought in the United States had a number put up by the plaintiff that would make it unresolvable, and every one of them is settled.
But do you see on the heels of that, there's been, I guess, question, does NAR go away? I mean, is NAR always going to have a home here? And I know that's a big TBD there, but, with what's that change look like from an association level?
That's
probably something you guys need to talk about with John, and what that relationship, a lot of that has to do more with NAR strategy. Don't forget, there is this thing called the bankruptcy court, right? There's been tons of companies out there, guys, that, look what happened to the tobacco industry. Can you not buy cigarettes anymore? Right? Look what they survived. Okay. So these things are all survivable. Can NAR survive this? Absolutely. NAR doesn't have to go away. It's just a function of how is that going to be structured? How is this going to be resolved between, all of the different parties that are involved? But this doesn't need to be an existential threat to NAR organized real estate at all. I think this is a resolvable matter that the parties can come together and do something about. The plans are never getting 13.5 billion. That's never happened.
And again, and I understand the speculative nature and what if. I've been playing what if games with Ed and with other people for the last 6 months. I'm going to have a what if conversation with the board of directors at Southwest fairly soon, and we're going to do all that. And that's under the behind closed doors. Pauline, who I see has joined us. Hi, Pauline. Is leading the board into making sure all of these issues have been discussed. Adam is staying on top of a lot of stuff. And this is my personal opinion, just like Ed just gave his personal opinion. Ed and I agree on almost everything. I'm a little more optimistic. I think NAR is going to win. I think that I don't worry about motions for summary judgment. I'd have been shocked if they would have won. I don't worry about class certifications. I'd have been shocked if they would have won the motions to oppose the classes. when we get to the merits of the case and you start drilling down into what the plaintiffs are claiming, are there going to be changes to the way you guys do business? Yeah. But, you know, again, will it settle? It's going to settle if they come up with a way to make it a universal settlement. Because remember, these cases are pending in Missouri and in jurisdictions covered in Illinois. What about all the other states? What about, how do you, and I'm not a federal practitioner, but how do you make the settlement universal? Again, I've had conversations with some high up people, and you know, the sense they get is we are not even halfway through this whole process. Whether we are or not, no one really knows, right? What you guys need to do is this: keep up. You know, you are moving into an era where not having a written buyer representation agreement will affect the way you might get paid and your standard of practice. Let people like Ed, myself, Robert, we're pretty smart. We're staying on top of stuff. The board has been gracious, and allowed me and you know, Art has allowed Ed to do our jobs. And really that's all we can ask. And we'll keep you posted. We'll let you know if there's a time to panic. We're not anywhere close to that yet.
And don't misinterpret, if I could, too, my words. Just because I'm here to give you an update on what the sellers are arguing doesn't mean at any level that I think that they're right. I agree with John. I think this is a winnable case by NAR, right? But I'm asked to come and explain what's happening, what the claims are, what could happen, kind of a scenario. So please don't interpret that as, you know, a thought that, you know, I think NAR's best argument here is that, you know, buyers pay the commission, and that kills the entire seller case.
It seems to me that if you ever wonder why you should be part of a realtor trade organization, now's the time, because CAR is doing an incredible job of keeping you guys up with forms and Q&As and all that stuff, right? The board is doing an incredible job of, you know, trying to maintain, you know, the information channels so that you're up to date. And of course, Ed works for, if not one of the finest MLSs in the nation. A lot of people are doing a lot of work behind closed doors to make sure that all of this is going to have the best possible outcome. What you need to do is two things: write a check periodically for the political action stuff, because this stuff costs a lot of money. I mean, we are talking about a lot of money at the NAR level, at the CAR level. Adam's salary is through the roof. And so, I'm kidding. And so you're looking at a lot of money, You know, Chubb is paying most of the cost of the defense of this case, and they don't have the kind of money they need to, you know, to do what they need to do. So write a check periodically if you can, and then keep up and don't panic. I guess that's the third thing. You know, let all of us do our jobs, and I think this is going to have a favorable outcome, because some of the attorneys that are working for NAR, and certainly at the CAR level, really pretty fine lawyers in their own right. So we'll keep you posted. Come to the ground. You'll see me in long pants. It's quite a treat.
And I promise John made that comment about the political action stuff on his own, but I will second, third, fourth, and fifth that all day long. I do also want to point out, as John did, we've got our board president, Pauline, and a few other board members on here. This is not the first, second, or third time that we've had these kind of discussions. We've been keeping up. We've had a lot of the what ifs, a lot of the changes. So I just want everyone here to know that your local board of directors is also very informed and very engaged in this conversation, and taking opinions, concerns, and all of that to the appropriate levels as well.
And all of the conversations, for anybody that's a bad guy that might be listening to this, have been privileged. So don't ask. We aren't going to tell you what we're talking about. They're all privileged. And like I said, I've been getting great cooperation. I'm really appreciative, all joking aside, of Pauline's leadership and then last year's leadership. It's been phenomenal. And so, and then Ed keeps me up to date and I have other sources of information. So we're okay. We're okay. Learn about the CB, the buyer representation form. That's your chore for now. Let the other stuff take care of itself. And for those of you that do property management, find a different career. Because it's just too,
It's not the rule.
it's too crazy out there.
Speaking of property management, we've got another, it's kind of lengthy, so I'm just going to read through it here, Robert, if you don't mind, but a question for you. And it says on the updated property management agreement, there's a property disclosure that's close to very similar to a TDS. And this particular member is having some owners complaining about having to complete, since so many owners have limited information, especially coming from another management company, say to a new management company. Is there a best practice or advice if a property owner wants to refuse filling that out, besides just not taking on management of that property?
Right. Okay. So we did introduce a new form in December. The RPOD, boy, what does it stand for? Residential Property Owner Disclosure. And the intent of that form was basically to help the property manager prepare the property for rental, to let them know what's wrong with the property and what needs to be done with the property, and also to help them avoid making misrepresentations about the property when they're advertising, when they're talking with a tenant. So that was the main focus of that form. It was not to be delivered to the tenant. And that was written into both the lease listing and the property management agreement as an additional disclosure that the owner would sign. Well, they also basically integrated all of the tenant disclosures into that same form as well, sort of like the idea of getting it all taken care of at one time. And immediately there was some pushback, there was a lot of confusion. Well, which portion of this goes to the tenant? Which portion of this is just for the information given to the property manager? So immediately they made the decision to split that form into two new forms. One, the same name, the RPOD, Residential Property Owner Disclosure, and that form is going to be given just to the property manager. It's just for the purposes of informing the property manager to prepare the property for rental and let them know any kind of defects on the property. The other portion of that, called the RPOQ, I do not remember what the acronym stands for. That is the part that will be given to the tenant. So in the new form, which will be made available very shortly, it's very clear exactly which portion goes to the owner and which portion goes to the property manager and which portion is to be given to the tenant. So that will be very simple and straightforward come June. Now, having said all that, if you're taking a property management agreement and you don't want to put the owner through the hassle of going through that form and having them sign, fill out all the questions, everything, I mean, then you could essentially go back to what you were doing previously, which is you look at the residential lease agreement, you go down the list. There's a disclosure section in that lease agreement. You just simply go down that disclosure section and you have the owner make all of the legally required disclosures per that section. And it doesn't have to be done at the time you take the property management, although it makes sense that you would, frankly. But you can do it that way. You would have to line out that portion of the property management agreement, which requires them to provide you with the RPOD. But it will become a lot clearer in just a couple of weeks, I think.
Great, thanks for that, Veronica. Hopefully that helped answer your question. John, we've got a question here about the buyer broker representation form. And someone's asking, can those be used when you're working with a client that's looking at a new build that may not be offering co-op with the broker? Can that form still be used?
Yeah, I don't think there's any restriction on the type of property. So yeah, I believe it can be. And Yes. Wow, it's hard for me to just say yes.
Not
Awesome.
enough billable time there for you, John?
I'm stuttering, but yes.
I'm going to address something in here. This was, I believe it's Venus or Venus Gonzalez one, as we put. I'm sure everyone has seen. There's been all kinds of social media news coverage talking about the proposed loan level pricing adjustment fees taking effect May 1st. And it says in here, I hope this will not materialize. Unfortunately, it is still set to take effect May 1st. I will let you know that NAR has been very active and vocal in their meeting with the FHFA director. They met early in the year talking about some of these fees. And then since the announcements have come up, they've continued to meet. There was a great article published in the Realtor magazine online, as well as a couple of newspaper articles. And then a letter was recently sent directly from NAR requesting that they eliminate these fee increases. They feel there's better ways that that program can be addressed. So it is being fought. It is being discussed very heavily. But as of at least yesterday, those new fee limits are set to take place on May 1st. But stay tuned. As I mentioned earlier, we will be going to Sacramento next week and then Washington, D.C. the following week for our annual lobby trip. And we may be coming back with hopefully some information there. Once again, we are fighting. We do hear your concerns and we are working on that on your behalf. So just wanted to give that update there. Let me go back over here to the chat here. Another dual agency type question here. Would you recommend as a brokerage that the broker designates another agent in the brokerage to represent the other party instead of, say, the listing agent representing both sides?
It's better than not. I don't know if Ed agrees, but it gives you a little more ability to negotiate. But keep in mind that the broker is a dual fiduciary as well. You know, the way Hurricane was decided and the way, you know, that the law is interpreted is the broker is going to be has a fiduciary obligation to both the buyer and the seller, coupled with a duty to supervise. So depending on the size of the office, et cetera, et cetera. But yeah, I think it would be better. I think it would be, you know, give you more defenses. From a risk management perspective, I don't think there's any question, and the statistics bear this out, that there's a higher likelihood that you're going to fall below the standard of care as to one or both parties in a dual agency situation. But having two separate brokers, or excuse me, two separate agents represent the parties does give you some additional level of protection. I don't know if you guys, if Robert or Ed agree with that. That's just my personal view.
It's an interesting element that I had to learn being an agent in California for 15 years under that current system that John talked about, right? We're dual agencies at the broker level, and our forms say just a couple of things, right? Are you a dual agent or not? Everything's at the broker level. This is the hardest thing for me to learn when I made that transition. You realize other states don't do that at all. They apply the common sense approach that you just suggested. So in Tennessee, we have like 6 different choices to make on that same form. And one of them is called a designated agent. So what happens is when I take a listing as an agent, the broker designates me as an agent for the homeowner on the listing. And I am now barred from representing anybody as a buyer. But another agent in the firm, in the same brokerage company, can be the designated agent for the buyer. And that is not considered dual agency. Dual agency in Tennessee is only at the agent level, not at the firm level. Then we have other things called, but you can be a dual agent, right? You can mark on the form that I'm the actual agent for both. You can be what's called a facilitator, which means I represent nobody, right? So we have these other designations. But that common sense approach you suggested makes sense. It's good common sense, but it really doesn't do much for you in the state of California because your laws are what the laws are. So
the key is if you want
much
common
controlled
sense,
by the Trial Lawyers Association. So
the key is if you want common sense, come on to Tennessee.
Are you guys getting paid by the Department of Tourism in Tennessee or something? What is going on?
No, actually, I think both of us would like to see the influx of people, now that we're here, have the moat raised a little bit and maybe not have so many of y'all coming, because I think the bigger
is that what
argument
it
here
is?
is all of these new houses that are going up. I'm not sure how many trees we're gonna lose. So, no.
What I'd actually like to see is that California, from a legislative perspective, actually adopt some of these programs from other states that work extremely effectively to protect the consumers while still allowing realtors to do what they do in a very commonsensical way, right? Because let's be honest, we have I think my largest brokerage firm in CRMLS has over 4,500 agents in the firm. Do we really think that there's a breach of fiduciary duty because one of the 4,000 agents is representing the buyer and another one in 4 offices away is representing the seller, and they probably never met and don't even know each other's names? Do we really think at the broker level there is some kind of communication going on behind the scenes that would rise to the level of a dual agency problem? Right. So I think there's just some other common sense solutions that have been implemented. And what I would love to see is that California actually implement something that we know for a fact works extremely well in other places.
Here in
I
Tennessee,
think
they
we'd all
do
like to see some more common sense take
well,
place.
here in Tennessee, they do something that I really like as a consumer, because I'm helping, like I said, now that I'm pretty much done with my purchases, I'm helping my best friends, who I can't wait to have move here because he's like my brother. And when you go on the MLS, and Ed knows this, all of the disclosures and all of the related documents are already there in the public section. So I can literally click on, and before I send Will or Realtor or my wife or I go to look at one of these properties, I've already reviewed all the disclosure issues. And our TDS, I won't say it's the same, but it's somewhat.
It's 98% the same.
Yeah, it's Tennessee does a great job of plagiarizing a lot of the forms that come out of California, CAR being the, one of the leaders in that regard. And we do that. And again, that's part of the problem with California, in my view. And I'm saying this as your lawyer, and that is there's so much gotcha, right? What Robert's going through, a lot of that makes absolutely no sense, but it puts the landlord or the rental property provider in a very precarious position, which in actuality raises the cost of housing, because they've got to take into account lawyers and delays and not getting paid and all this other stuff. It doesn't solve the problem. And so you perpetuate problems and create new problems. And it really is very, very sad, actually.
Yeah, the rules out here are designed to protect the consumer, with the same time recognizing the realities of what it takes to be a realtor and do a good job. So our MLS rule out here requires that within 4 days of posting a listing, you upload the TDS into the MLS for everyone to see. And the common practice here is when you submit an offer, I've done this on every buyer I've ever represented, when I submit the offer, I include the fully signed TDS as part of the offer package, so that the seller understands when they got the offer, the buyer's already seen the full TDS. And so my price that I'm offering includes an understanding and a number that adjusts for whatever disclosures may have been made in the TDS. And therefore, as I think John would agree, the chances of getting sued for a failure to disclose situation drop immensely when it's actually part of the transaction between the buyer and the seller.
In California, there's actually a case that says that the TDS is not part of the contract documentation. It's a separate disclosure, and it just creates confusion. And I understand the reason for it. I think a TDS is a good thing, but coupled with what I think is one of the greatest risk management forms I've ever seen, which is the SBQ. When you put that together and you provide it ahead of time, and then you get it as part of the offer signed already. First of all, you eliminate all that delivery issue and all this other, because you've already done it, right? And now you're at a much higher level in terms of parties negotiating. It's just really too bad. You guys would do.
Yeah, it seems like a very good practice. I would say that as a practical matter, it was only possible to do that maybe in the last 15 years.
Yeah. Well, nobody lived here 15 years ago. It's all, everything's happened in the last probably 10 years.
And
Well,
also,
and you guys
Northern California, if any of you have done deals up in the northern part of the state, in California, the providing the TDS early and that being part of the process before you make an offer is almost routine up there. So this is one of those examples where Northern California actually has already kind of adopted much more of the style of practice of getting the TDS out before an offer is made.
And I just want to comment again on something John mentioned earlier with the political side of things. You're right. There's just a ton of regulation. For those that may not know, there was over 2,700 new bills introduced this cycle. And about a month ago or so, I went to Sacramento to meet with CAR's lobby team. And of those 2,700, they were closely monitoring just over 800 of those because of their impact on the real estate industry. And that's just this session and this cycle. So we stay very active.
And I believe California has a fairly high passage rate when it comes to bills, that make it actually that make it to the legislature. Bill that has actually
900 new laws that went into effect on or about January the 1st. 900 new laws, over 900 is into the mid 900s, and you're probably going to have that same number again this year. It's just, and at some point it becomes a diluted joke because nobody can keep up with all the laws, and that's just the laws. Then you've got all the regulations that each of the departments puts into effect to carry out the laws. You've got a new implied bias training, and now the DRE is issuing the regulations related to implied bias training and all of that kind of stuff. So yeah, it's fun. And I don't think we had 900 laws on the books.
Yeah, probably not. Did want to clarify one thing. Also, I mentioned the May 1st date as far as the loan level pricing adjustments. Those fees are already in place. May 1st is the delivery date, so that when loans were actually going to be sold off. So we are already seeing those. I also did put in the chat for everybody a link to a PDF. That's a copy of the letter that NAR issued to the FHFA director. So if you'd like to see that, please go ahead and click on that. And then as a reminder, I've gotten a couple of questions. We will be able to share a copy of this recorded presentation along with the slides that Robert shared with us earlier today. So we'll try to get those out to you guys here in the next couple of days. Checking one other thing in here. I don't see any other questions coming in, which is kind of a shock, but usually that indicates either you guys did a fantastic job, which I think it's A, or B, we're just so overwhelmed with all the positive news that you shared with us this morning. We don't know how to control ourselves. But I will say I will say once again, John, thank you so much for help coordinating this. Robert, Ed, thank you so much for joining us. We've said it a million times today, staying educated, staying up to date. That's the only way we're going to be able to stay successful, and being able to have you guys participate and share your areas of expertise with us is extremely valuable. So we appreciate you taking the time. All right.
Thank you very much. And I want to thank John for inviting me to this meeting.
Well, I needed the education. I was selfish.
I will also plug one more time. We will be hosting a live brown bag update on May 26th at 9 a.m. So keep an eye on your email or maybe our website and social media for information on that, because I'm sure that will be very well attended. And John always shares a ton of information for us there.
And if you have something you want me to talk about, since it's pretty loosey-goosey, that I'm going to talk about this, the BRBC. I'm going to talk about some new laws, but if there's something particular that you want me to address, let Connie know, and she'll forward that to me, or let Adam know, And I will make sure that I cover it if I think it's relevant to the general membership. So we'll do that for sure.
All right, well, I appreciate that, John. Ed, Robert, thank you once again. To all the participants, thank you so much for spending the last couple of hours with us. Hopefully you got as much out of it as I did, and we look forward to seeing you at the upcoming event. Go out and make it a wonderful day, guys. Sell some real estate, and we'll see you guys soon.
Great job, Adam.
Ed, give me a call about something, all right? When you get a chance, not today.
Not today?
Well, it doesn't have to today.
Okay. You can stay on if you want once everyone logs off if you need.